together SJC-11688, Gregory, Diatchenko v. Commonwealth and another, and SJC-11689, Commonwealth v. Jeffrey S. Roberio.
Good morning, Mr. Keehn.
Good morning. May it please the Court, Benjamin Keehn, Committee for Public Counsel Services, on behalf of Gregory Diatchenko and Jeffrey Roberio. I've asked Mr. Connolly to give me a heads up when I've got about 6 minutes to go to remind me, if I have not already turned to the specifics of Mr. Roberio's case, that I don't forget to do so. These two cases are both here on reservation and report, and they present reported questions regarding the specific parameters of the constitutional remedy for the 65 juvenile homicide offenders in DOC custody whose life without parole sentences were invalidated by virtue of this court's ruling in December, applying the rule of Miller versus Alabama to the punishment that was imposed on Gregory Diatchenko 33 years ago.
So let me just interrupt you for a second. So your argument, whatever you're going to say, only applies to that class of people, not to, it doesn't, whatever you're going to say, doesn't apply to a juvenile who may be convicted today of murder in the first degree.
I would agree with that statement. A first-degree juvenile offense committed today would be governed by the statute as amended a few months ago. So this is talking about the retroactive remedy for this limited group of 65 individuals who were convicted and sentenced prior to Miller. Now, my intent was to spend the bulk of my time on the three related reported questions in Mr. Diatchenko's case, and I still think that that's how I would like to try to proceed. Before I get to the first reported question, which is really the threshold question, whether these 65 juvenile homicide offenders have a right to counsel at the parole hearing mandated for them by Diatchenko 1, let's call it. I want to update the court regarding Mr. Diatchenko's case. He had a hearing. He was given a decision a week ago tomorrow in which the parole board granted parole after 12 months in lower security at the Department of Correction, during which time he must maintain good conduct and comply with all DOC expectations for programs, activities, and employment. The respondents have filed a suggestion of mootness in light of this positive decision by the parole board. And I think, I filed a quick response yesterday or the day before to that suggestion of mootness. I think the reasons why, in the petitioner's view, this case is not moot despite this decision is as good a place as any to illustrate why a right to counsel means something in these cases. The record in this case establishes that the parole board has no control or authority over whether the Department of Correction when or whether the Department of Correction moves an individual from one place to another. This is at page 85 of the record in the Diatchenko case. This is the affidavit of Attorney Guerin that was filed in the original petition. The current parole board refers to all reserve votes, conditional votes, if you will, as positive votes, notwithstanding the fact that due to the kind of issue identified above, prisoners who receive positive votes may never, in fact, be paroled.
So could the parole board here have said, He will be released within 1 year. We strongly suggest that DOC put him into a pre-release center to ease his transition. And DOC doesn't do that, he gets released in a year. Is there anything
I
that
doubt that would happen, but I
But is
believe
there-
he would have a good argument.
Is there anything that requires him to go to pre-release for a year?
No, this is the parole board's policy
It said he had to be in lower security for a year, is that right?
for 12 months.
For 12 months, yeah.
Incident-free, yes.
Okay.
That's it's a conditional grant of parole, conditioned on him serving 12 months of incident-free time in DOC lower security status. As of today, he remains, as far as I know, at MCI Norfolk, and he is requiring the assistance of counsel, namely me, to cajole, persuade, push, bug the Department of Correction to move him as quickly as possible to lower security when the 12 months will begin to tick.
Why isn't Prisoners' Legal Services an appropriate resource in these circumstances?
Well, because Mr. Diatchenko has a constitutional right to a meaningful opportunity for release based
He
on...
has had a meaningful opportunity for release.
Not
He
if,
had a
not if the
hearing.
DOC doesn't transfer him. If the DOC fails to transfer him, this decision by the parole board is not worth
Come
the paper
back
it's
to
written.
us. Why wouldn't you go back to court or back to the parole board in that instance? And this is a week, not even a week.
I'm not saying that this won't happen. The question is whether the case is moot at this point by virtue of the fact that he's received this decision. And my point here is that he may or may not be released to the supervision of the parole board.
And does this often happen? Does this often happen where these decisions are made and the Department of Corrections refuses to comply?
I wouldn't
Does
say
this something happen
refuse.
all
The
the time?
record indicates that the Department of Correction, I think this is also in the affidavit of Patricia Garrett, that they simply take their time. And it can be months, and sometimes such prisoners are never, in fact, paroled for whatever reason. So that's the evidence. Now, before, I'm sorry.
Well, no, I was just trying, because it seems to me, regardless, Mr. Roberio has this, I mean, I'm trying to move you to the
No.
three issues.
Yes, thank you. So yeah, the point is, it is the remedy that this court established in Diatchenko 1, a hearing at which he shall be provided a meaningful opportunity for release, is not self-defining. And in the context of the bureaucracies that are involved here, any one of these 65 individuals, assuming indigence, is entitled to the assistance of counsel, appointed counsel, to make that process mandated by Diatchenko 1 a meaningful one. I hope that the DOC, to respond to Justice Cordy's question, transfers him forthwith. And I hope, and I have reason to believe, given the status of Mr. Diatchenko's case and the attention it's gotten, that he will receive the attention of a squeaky wheel and be starting his 12 months to parole supervision sooner rather than later. But let me now turn to not the specifics of Mr. Diatchenko's status today, but more generally where the right to counsel that we are advocating for comes from. I think that this is implicit in at least two aspects of the Diatchenko decision itself. And first, the court states in footnote 18, final footnote of the majority of the court's opinion, that the heart of this case pertains to how to effectuate, I'm paraphrasing here, this new Eighth Amendment right, this new Eighth Amendment rule of Miller, for purposes of measuring whether the fairness of a criminal punishment that has been imposed upon a juvenile offender meets constitutional standards. And the court says that this case is about sentencing, about punishment. And therefore, there is a right to count. This is in response, by the way, to the Suffolk DA's motion to disqualify the Committee for Public Counsel Services from representing Diatchenko now, at this juncture. And the court denied that on the rationale, which had been offered to the court in an affidavit from the chief counsel, that in our view, this is functionally the equivalent of sentencing for these 65 individuals, and it's well established that there is a right to counsel at sentencing. I think that is the cleanest.
But it surely didn't go that far. It didn't say there's a right to counsel at the parole hearing.
No,
it
it
didn't say
didn't.
anything close to that.
No, that's in fact why we're here. Well, I wouldn't say it didn't say anything close to that. I would say that it didn't address it because it wasn't presented.
The present proceeding is highly unusual, but we conclude that it is still part of the sentencing process. Highly unusual, because this was a challenge to the underlying sentence, which was mandatory life without the possibility of parole.
And I think that these 65 hearings are highly unusual, quasi-parole, quasi-sentencing remedies for individuals who this court has declared have been sentenced unconstitutionally. And
Except that now you're, in the Diatchenko appeal, the defendant was precluded from proceeding to the executive branch of government for a parole hearing. And we said, you can't do that. He's got to be presented to the executive branch for an opportunity to gain parole. That has occurred. We're in a different forum now, aren't we? Or Mr. Diatchenko is in a different forum. He has gone before the executive branch.
yes, I agree with that. In terms of the reported questions, I think what the issue is whether this court, whether the judiciary has a role in ensuring that the remedy that it declared to be appropriate in Diatchenko 1 requires the protection of a declaration of a right to counsel to ensure that that hearing is meaningful. It is our position. I'm sorry.
Yeah, let me ask you, and this may be related to what you're presenting. If there is not a meaningful opportunity for parole, am I correct that the life sentence becomes an unconstitutional sentence because it's cruel and unusual?
Yes.
Is there any, apart from the juvenile life sentences, is that true for any other type of sentence? Is there any sentence in which the absence of a meaningful opportunity for parole would make the underlying sentence cruel and unusual?
I don't believe so. That language, that this is the constitutional meaningful opportunity for, not for parole, for release, based on demonstrated,
correct, right.
demonstrated maturity and rehabilitation, comes from Graham, the predecessor to Miller versus Alabama, picked up in Miller, picked up in Diatchenko in a somewhat ambiguous way because it truncates it in the shall paragraph, shall provide a meaningful opportunity for release, and does not in that paragraph say on the basis of demonstrated maturity and rehabilitation. This is juvenile. This only impacts
juvenile life,
juvenile
Right.
first and
offenders.
second degree.
Well, that's the only mandatory life sentence for juvenile, maybe for anybody, but for juveniles.
I'm sorry?
Well, first and second degree murder is the only mandatory life sentence that would apply to a juvenile.
That's true.
So let's put this in a somewhat different framework. Let's assume that the sentencing judge, assuming that he or she is still there 15 years after sentence, says, I sentence this person to life, which is a lawful sentence only if there is a meaningful opportunity for release, and I conclude there has not been. What does the judge then do?
Well, I think that's sort of analogous to the situation here. The judge would make sure that, in fact, that the hearing designed to create the meaningful opportunity for release, that the juvenile offender had a lawyer, had whether or not he could afford it, he had access to funds to present the mitigating circumstances of his case that are now, I believe, in light of Diatchenko and the concurring opinion, constitutionally required to be presented. And if there was a flaw in the proceedings, the juvenile would be permitted to appeal, which gets to our third reported question. And
Well,
that's how the judiciary would enforce it.
If he were convicted of armed robbery and the judge sentenced him to life in prison, would he also be entitled to a lawyer before the parole
A
board?
juvenile homicide
Yeah.
offender sentenced to life?
No.
No,
armed
juvenile
robbery.
armed robbery.
I'm sorry, a juvenile armed robber sentenced to life with the possibility of parole after 15 years, I would say is in the same, the logic of Miller and Diatchenko requires that juvenile offender have a meaningful, have a parole hearing that is not the standard parole hearing.
How do you come to that, not the standard parole hearing? Where does
Because
that come from?
It comes from Diatchenko itself.
Doesn't come from Miller, doesn't come from Graham. I don't see it in Diatchenko.
Well, Diatchenko ordered the hearing as the remedy for the constitutional violation. So that's where it comes from.
And as a result of Diatchenko, ordered a parole hearing. As a result of Diatchenko, the parole board has adjusted their guidelines to take into account the very factors
Right.
that this court said would be appropriate and to ensure a meaningful opportunity.
Right, and kudos to them. My point is that absent a lawyer present to represent that juvenile offender at the hearing ordered by Diatchenko 1, the hearing may be meaningful or it may not be meaningful. And there will be nothing that either the juvenile offender or this court could do about it if it were not. That's what this is about.
And if the juvenile were sentenced, let's say armed robbery conviction, were sentenced to a term of not less than 3 and no more than 10 years, and so that he would be eligible for parole, what is it, after 3 years? If he were not paroled, is he entitled to a lawyer at a parole hearing then too?
I think that's a different case because we would not be talking about a life sentence.
Isn't that certainly one of the issues? It's the life
absolutely.
sentence.
I mean, Miller is talking about death in prison, and 3 to 10 is not that.
About 45 to 50 years. He would
That
be,
I would say is a de facto life sentence for a juvenile that would certainly violate the spirit, and I would be happy to make the argument also.
But let me ask you this.
intent.
If you, well, as you say in your brief, you know, the remedy that you had sought originally was go back and have an individualized hearing, I believe.
In front of a judge, right.
And so let's assume for the minute that happened. Well, would you say, and would you say that then you also get to have, if you're a juvenile, you have an individualized hearing? Do you also, and the hearing says life sentence at the end of that's what the judge says at the end of the day. Yes, I think that this person should get a life sentence, and parole with parole eligibility at, let's just say when it's set at 15 years. Does the juvenile, because he is or she is a juvenile, also get, would you argue, at the parole hearing, these rights that you are now talking about?
Yes, because unless that parole hearing is an enforceable legal proceeding, as opposed to the current law for adult offenders, where parole can be granted or denied for a good reason, a bad reason, or no reason at all, the juvenile offender, we cannot be sure with any degree of adequate certainty that hearing will in fact deliver the constitutionally required meaningful opportunity for release based on demonstrated maturity and rehabilitation. May I turn to the facts of Mr. Roberio's case, which are significant and in a different posture. This, in his case, prior to Diatchenko 1's decision, he filed a motion for a Rule 30 motion for resentencing. And in connection with that, filed a motion for funds for an expert to testify about Miller factors. Specifically, his defense at trial was insanity. There was evidence of significant neurological deficits and problems. And the issue now is whether he is entitled to funds for an expert to show the parole board that the neurological problems that the parole board will be certainly focused on have resolved. If he does not have such an expert, I would be wary of a parole board that said, without expert assurance, that an individual who claimed 28 years ago, lacked the ability to control his behavior as a result of organic and other neurological problems, was now mature and rehabilitated.
Has he seen a doctor in prison since he was first convicted?
Yes. In
You know,
connection with his,
as part of the prison system?
no.
No,
Not
no,
that I'm aware of.
no psychiatric treatment or psychological treatment.
No, there is, no. He received evaluation as a result of the appeal of his initial conviction, and we have in the record a longitudinal study of Mr. Roberio's neurological maturation over a 28-year period of time.
And those are records of the DOC?
No, these are records that were generated during the course of the prosecution and appeal of Mr. Roberio.
Back then.
Back then, and recently.
Okay.
Before the Commonwealth filed its 211-3 petition, I prevailed upon the forensic psychologist who evaluated him back in the early 90s.
Dr. Spears?
Dr. Spears, to do so again. He did it without knowing whether he'd be compensated, and then he died, unfortunately. And so that's where Roberio's case is. There is compelling evidence that the parole board, needs to hear as to why they can be assured that notwithstanding the significant neurological and other related issues that resulted in the commission of a terrible crime by a juvenile with untreated mental illness, is now mature and rehabilitated to the extent that
Can I
his
just ask you a
release-
practical question? If this court were to say that somebody in Mr. Roberio's circumstances is entitled to counsel, and presumably that's the Committee for Public Counsel Services, as a statutory matter under 211D, wouldn't you have the ability to retain an expert to do just what you're saying?
Not without judicial approval, or some sort of approval. And I would commend the court to the amicus brief filed by Mactel, authored by a former assistant general counsel to the parole board, as to a suggestion for how the actual process for authorizing the expenditure of funds might in fact work, analogizing this situation to what is existing currently statutorily for the SORB cases.
Can this be developed through a budget line item for prison legal services and have them do this work?
Sure. I don't see, that could be, but the key would be a declaration from this court that those legal services were required, that they had to be provided, that the indigent status of the juvenile offender could not be a bar to the receipt of it. If it comes from PLS or CPCS or any other S, I don't think that's determinative.
All right.
Thank you. I'm well over time, and I
I
appreciate
gave you
the
that time, thank you.
opportunity.
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth in Commonwealth versus Roberio. Your Honors, we've agreed that I would take in 9 minutes of argument on the initial argument here. Your Honors, in this case, in the joint case brought by Mr. Diatchenko, the defendants are both asking the court to read the earlier decision of Diatchenko as recognizing some kind of constitutional mandate that required a special kind of parole hearing for juveniles who were convicted of first-degree murder. However, no fair reading of Diatchenko leads to that result.
Let me ask you the same question I asked your brother. Let's imagine a judge says, I sentenced somebody to life in prison. That sentence was constitutional only because the person was intended to have a meaningful opportunity for release, and I find that the person did not have that meaningful opportunity. And therefore, my sentence effectively is life without the reasonable possibility of release, and that's unconstitutional. What is a judge to do?
The judge can't do that because that would be interfering with the executive prerogative of the parole board, Your Honor, and that's under Commonwealth versus McGinnis and Commonwealth versus Amaral. The court here
But I think
simply-
Chief Justice Gantz's point is that if, as a matter of the Eighth Amendment or Article 26, it was, the judge was required to impose a sentence that offered a meaningful opportunity for release, and the judge determines that there wasn't one, what the judge has done is impose a sentence, a mandatory life sentence that both Miller and Diatchenko says is not constitutional.
Your Honor, what Diatchenko says is that what the judge can do is impose a life sentence. What Diatchenko says is a life sentence remains in full force and effect. It goes on then to describe the ramifications of that remedy it's done, and that is that the matter can then be presented to the parole board, and that it's the purview of the parole board to consider the circumstances of the crime as well as any evidence of maturity and rehabilitation, and determine whether release is appropriate. Diatchenko specifically said that it was doing as little as possible to the established statutory scheme that it had to do and to make the statutory scheme constitutional. Brown, the case that came out the same day on the same subject, said specifically one and only one application of one provision of the scheme has been deemed unconstitutional, and that is the aspect that made these particular type of first-degree murder convicted.
Just going back to my question and Justice Botsford's question, we can do life with the possibility of parole, but if the judge 20 years later says, who we kidding, there was no possibility of parole here, what does a judge do? The judge then says, golly, I imposed a sentence for all practical purposes without the possibility of parole. That's cruel and unusual under Miller and Diatchenko.
Without
Does the
the
judge
opportunity
just
for release.
shrug his shoulders and say,
Your Honor, the flaw in the hypothetical is the judge does not maintain continuing jurisdiction over the sentence. The sentence is life without parole, and at that point, the case is over. Once that's affirmed, the case is over, and the judge has no longer the supervisory authority over that sentence.
I suppose,
That's a matter
Mr.
of
Thompson,
constitutional law.
I suppose, I mean, you are correct. However, one could bring a declaratory judgment action and try to establish that the board has systematically not been providing meaningful opportunities.
Which is
however defined.
essentially what I was going to say next, Your Honor, and I absolutely agree with you. If a defendant believed that he had not been given a meaningful opportunity for release, his remedy is to seek an action for declaratory relief as parole board have. And if the defendant could somehow show that, contrary to the expectations indicated by this court in Diatchenko, that the parole board had not, in fact, giving a meaningful opportunity for release, then some relief could be available. That, of course, has not been, there's no showing that, in fact, the parole board does not give meaningful opportunities for release in these situations. And in fact, Diatchenko's case itself shows something quite to the contrary.
But if that were something that could be brought, the declaratory judgment action, what would the judge in that case do? Would the judge have to come to the same conclusion that if the judge decided that there was not a meaningful opportunity for release provided, that the original sentence imposed was in effect unconstitutional?
No, Your Honor, it would be to remand, to say that the denial of parole in that particular case was unlawful and perhaps unconstitutional, and remanded to a parole board to do it appropriately, Your Honor, and to give, in fact, a meaningful opportunity for release, for consideration of release. Your Honors, this idea, any idea that this is somehow, parole considerations are somehow part of sentencing that could give the judge continuing jurisdiction over the matter is belied by the principle set forth by this court in Commonwealth versus Cole. It simply cannot be that a court could not constitutionally give the parole board, as would have to have been done here, give the parole board authority to, over the sentence, to modify the sentence here. If it's still part of the, if parole consideration is part of the sentence, then that would be an unconstitutional delegation of judicial authority to the executive under parole, and there's no reason to believe that this court intended such an unconstitutional determination. This court specified exactly what it found unconstitutional in the statutory scheme. It was limited to the provisions that said that these particular type of first-degree murderers, the exceptions to parole eligibility could not be constitutionally applied. That was the extent of the decision. When the court went on to describe what it expected to happen, it then said that it will, or it shall, or will, the defendant will then be provided with a meaningful opportunity for parole that would satisfy the concerns of Graham. That is the consideration of the parole board.
But you agree, I gather, that even though parole is plainly an executive function, it's not an invasion of that to permit a declaratory judgment action.
I agree with that, Your Honor. Certainly
Is it an invasion of that to permit a certiorari action?
Your Honor, to the limited extent that certiorari, I mean, the court, I think, believe in the past has exercised the certiorari and declaratory judgment to review parole board decisions, and I'm not suggesting that one is exclusive to the other. There are avenues in existence for defendants who claim that they have not been giving a meaningful opportunity for parole, that the parole board has somehow abused its discretion or acted in an arbitrary or capricious manner, that it can be brought before a court, and I would absolutely agree with that, Your Honor.
Okay, so let's imagine there to be a declaratory judgment action which says, in the circumstance of a juvenile, because we're asking a rather extraordinary form of analysis to look to see whether or not in the passage of time the juvenile's brain has changed so that where he was plainly dangerous earlier, he no longer is, that requires an attorney in order to have a meaningful opportunity for release. Would that be an inappropriate judicial role?
Your Honor, again, the premise of the court's question is that the court has somehow established that the defendant is entitled to a parole hearing that is particularly emphasizes the so-called Miller factors. That was not as what was done in Diatchenko. Diatchenko merely said that the parole board can consider the circumstances of the crime, including a defendant's age. The parole board always does
Wait, I'm
consider
sorry.
the circumstances of the
Are you
crime.
saying the parole board can say, yeah, I know that I read that stuff about the juvenile mind, we're going to ignore it? Is that something which the parole
Your
board
Honor, the parole, I
permissibly can
doubt
do?
that the parole board would
Could it, though?
ignore
Could it?
what everybody knows.
The answer is not, clearly it is not now. It is clearly set forth parameters that say, we will consider it. But is it your position that the parole board could say, that was done in the wake of Diatchenko, years have passed, we don't need to think about that anymore?
Your Honor, I think that the degree of what gets particular emphasis in the parole board is essentially up to the parole board. The critical issue is not the defendant's original culpability at the time of the murder. His culpability has been established. It remains there. His degree of culpability is no more than a starting point for consideration of whether he is currently of sufficient rehabilitation and maturity that his release is warranted. Your Honor, there's no constitutional mandate either here or in Miller, and in fact, in Brown, they specifically rejected any such broad reading of Miller as requiring any kind of far-reaching requirement of consideration of Miller factors whenever, as a constitutional mandate, whenever any kind of release or sentencing of a juvenile was concerned. That Brown specifically says what Miller did, what they said about juveniles being different, pertained to the question that was before the court, which is whether what they viewed as tantamount to a death sentence was warranted for juveniles, Your Honor.
All right, thank you.
May it please the court, Assistant Attorney General Amy Karangekis, on behalf of the Chairman of the Parole Board and the Commissioner of the Department of Correction. The reported questions do not pertain to DOC, and the Parole Board is going to focus on the judicial review issue before the court. The entitlement to judicial review of board decisions that petitioners seek in this case is inappropriate because it is contrary to Diatchenko, it offends the separation of powers doctrine, it exceeds the bounds of declaratory relief, and it is unnecessary.
Well, what if it were a sham? What if Mr. Diatchenko, and I'm not saying that it is, but hypothetically, what if they were all sitting around smoking cigars and drinking glasses of scotch and laughing it up and hooting and hollering and said, you don't have a chance? I mean, if it was that blatant and obvious, is there no remedy?
No, Your Honor, of course not. The remedy, and I think in Cole, in this court's recent decision in Cole, the court made very clear that there is no entitlement for direct judicial review, but it also dropped a note and said certainly there are civil remedies that are available for circumstances just like you're speaking of, Justice Spina. And they gave the example of declaratory relief. So that would be available, of course.
And certiorari?
That's a different question, Your Honor. And this court, we have found that has never applied certiorari review for a parole release decision.
Are you suggesting that it couldn't be?
I'm not saying...
It is a kind of adjudicatory, proceeding, sort of, quasi-judicial proceeding.
There are case law that say that one of the factors that look to make that determination is whether there is the availability for cross-examination. This court has talked about that in School Committee of Hudson at 448 Mass 576. A parole release hearing is different than parole revocation, where you have cross-examination of
So you're saying
witnesses.
you don't in a parole release hearing?
Correct. They're not entitled to cross-examination.
Now, I had thought that in your brief you said there would be certiorari review, but it's limited to arbitrary and capricious.
We didn't say that there would be. We said in the event that this court finds that there is, the standard should be arbitrary and capricious, but not the standard that's put forth by petitioner.
Okay, so let's take that standard. Let's take Justice Spina's example. Instead of bringing a DJ action, they say, this is an arbitrary and capricious exercise of their discretion. Plainly, there was no exercise of discretion. And we say it's arbitrary and capricious, and that you can't have a meaningful opportunity for release when they're acting in the arbitrary fashion that Justice Spina describes. Certiorari as a remedy for that?
It could be, Your Honor. We would say that the more appropriate relief or action would be declaratory judgment.
What would you be declaring?
That the policies and the procedures of the parole board were not being abided by.
So it wouldn't be a review of the decision?
Correct.
So if the policies and procedures, for example, you heard what counsel for the Commonwealth, well, what the prosecutor just argued, that the Miller factors need not be a part of the parole board hearing. And if they were not part of the parole board's policies and procedures, you're saying that's not subject to any kind of review?
No, Your Honor. What I'm saying is the parole board has to adhere to the laws of this court and the statutory laws and the Constitution. And if it doesn't do that, then they could bring a declaratory judgment action.
And I suppose the court might be able to release the prisoner on conditions of bail until an appropriate hearing were conducted? Or could they terminate his sentence?
Well, I think you're getting into issues of separation of powers there, Your Honor. When this court in Diatchenko said that the sentence of life is valid, this is no longer a sentencing issue, and now it's within the purview of the parole board to make a suitability determination that is separate.
So if I guess I'm getting back to the review of the decision. So if you have the policies in place, and the parole board simply blatantly ignores uncontroverted evidence, just hypothetically, but there's no, they have the guidelines that are currently in effect, but in this particular case, they simply don't deal with the evidence in any legitimate fashion. It's not quite where Justice Spina was, but they have a hearing and they're not whooping it up, but they simply ignore all the evidence. Could there be a review, or is that beyond the limits?
And I think that's where the case law is unclear, Your Honor, because I think there are a couple unpublished cases that say if an individual is attacking a parole decision, then it's more of certiorari review. So this court has never found that yet.
Okay, thank you.
Thank you.
Good morning, may it please the court. Jack Zanini for the Suffolk County District Attorney and the Commonwealth in the Diatchenko case. I just want to pick up where you left off. If the parole board had a sham hearing, I would suggest you could probably get a writ of mandamus and order them to perform their statutory duty and conduct a hearing, which was actually a meaningful opportunity.
They conducted
for
a
release.
hearing. I don't think mandamus would say the quality of it.
Yes, they didn't perform their legal duty, which is why the writ of mandamus applies to order them to
And how is
perform
that
their
different from certiorari? It was arbitrary and capricious what they did.
It may not be different. It may just be another form of writ that you could use. You could also arguably file a writ of habeas corpus to the extent you have a liberty interest. And sometimes we see in the federal cases where the writs of habeas corpus are used to do things like order, you can either conduct a new trial or the defendant's sentence is vacated and he'll be released. Similarly, you could have a conditional order, either conduct a real hearing or get some release, or maybe just order the release on parole with conditions of parole. So I think that, in any ordered system of liberty, any constitutional system, there has to be some form of judicial review. I don't think that's really in dispute. Secondly, there's a statutory issue here. The defendant concedes that and argues that only 65 people in the Commonwealth are entitled to this special parole hearing, that everyone going forward is not entitled to this hearing because of the statutory amendment. So if this entitlement springs out of the old statute, there are two fatal flaws to that argument. The first is that the legislature could amend the statute tomorrow and explicitly say those 65 people now have a right to a parole hearing, and it applies to them from this day forward. And by granting that statutory right to a parole hearing, you completely gut his argument that this somehow magically springs out of a constitutionalization of the statute. The second flaw is that these 65 people actually have the right to a parole hearing because of the statute under which they were convicted and sentenced, and that's what this court said in Diatchenko and Brown. In Diatchenko, the court specifically said, if you look at the enactment and adoption of the statute, there was a saving clause in the statute. And it said, if some part of the statute does not apply, and that being the exception to parole, the rest of the statutory scheme applies. And the court encompassed the parole hearing under that. Therefore, he has the same right to a statutory hearing based on his conviction in 1983 as the defendant does tomorrow. It was already encompassed within the statutory scheme. It was foreseen by the legislature. He has a statutory right to a hearing. It's just the same parole hearing as all of the other defendants, or prisoners rather, have. It's no different than that hearing.
Can I just interrupt you for 1 second? When you say, and I wasn't clear on where Mr. Keehn was coming down on this, is that in the defendant's either brief that they are not suggesting that any of this remedy would go to anybody beyond the 65?
He said it today in open court. I don't know that he explicitly said those words in his brief. What he did say in his brief was that somehow the court constitutionalized the statute and created this right to a hearing with all of additional protections that other people don't get. In fact, it's important to look at the motion for entry of declaratory judgment, which is at Record Appendix 102, and at Record Appendix 104 and 105, in that motion, asking this court to effectuate the declaratory judgment of the original Diatchenko petition and decision, he goes through and lists all of the intra-trial rights that he would have at a trial, and says, as part of the declaratory judgment, you have to give me and my other 65 in my cadre all of those intra-trial rights, and more. There's more in there. All that's reported is the lawyer and the funds, but they're asking and arguing in their motion that all of those intra-trial rights have now become engrafted onto the parole hearing because it's part of the sentencing hearing. So if that's true, he's got all these intra-trial rights that attached at indictment. They continue through sentencing, and if parole is part of the sentencing and it just goes on for the next 15 years, he's got all of those rights for the 15 years while he's in prison. And in order to prepare for his parole hearing and be in the best possible position to get paroled, I assume he has the right to funds for those 15 years. I assume he has a right to a tutor to prepare him for his GED. I assume he has a right to tutors and educational counselors for his college degree. I assume he has the right to psychologists for ongoing treatment. All of that springs out of this so-called constitutionalization of the statute. And I would suggest that all he's entitled to is not a guarantee of parole, as Graham v. Florida says. He's entitled to an opportunity for a hearing. He's entitled to the hope of release and the possibility of release, but there's no guarantee here. Unless the court has other questions, I will leave it with the brief.
Thank you. And we'll take our morning break.